Thank you, Madam Clerk. We're ready to call the next case, please.
Kristina Cole versus State of Tennessee.
Morning.
Good morning. May it please the court, I'd request 3 minutes rebuttal.
3?
3.
All right, 3 minutes rebuttal.
Yes,
Ready when you are.
I'm ready. I am here on behalf of Kristina Cole. I'm Attorney Tootin. I believe I've been told no by everyone on this panel, so good morning. This case it was titled as a writ of error quorum nobis. I saw the state's brief where they gave a little pushback on the label. Quite frankly, I do believe it qualifies as a writ of error quorum nobis, but I also don't believe the label really is relevant, and in criminal proceedings, it's the substance of the document. I believe it qualifies as a writ of error. It could also be considered a petition to reopen the case based on due process violations. Again, I'm really not too hung up on the label. I think the facts are what's more important. When this was filed in the state court, the state filed no response in opposition. The matter was reviewed on the merits, and then the trial court dismissed it without a hearing. The issue in this case was the defendant, Kristina Cole, realized and eventually discovered that there was an ex parte hearing that occurred without her being present, without her being made aware, without her having any opportunity to participate, in which this case was discussed before the trial court.
Mr. Tootin, let me just stop you for 1 second, just so I can get my head around
Okay.
where we are. Okay, this is a quorum nobis petition. And in your brief, you say the ultimate issue before the trial court in this court is whether appellant received due process under the law regarding the ex parte hearing that the trial court engaged in, separate and apart from whether or not there was newly discovered evidence.
Yes.
How does that apply? How does quorum nobis apply to that?
Well, and again, it goes to what I'm saying as far as label purposes. I believe that there's 2 distinct issues here. I think one issue deals with newly discovered evidence, and I believe that there's a separate issue dealing specifically whether or not a due process was complied with.
Well, let me ask you this. How does the due process argument give the court jurisdiction? You have to, this is a final judgment.
Correct.
And there's only certain ways you can bring a matter back before the court and give the court jurisdiction.
Understand.
Okay, quorum nobis is one if it's
Correct.
properly filed, and the second one would be a motion to reopen a post-conviction based on 3 very narrow circumstances. This due process argument, what vehicle does that give the court jurisdiction?
And that's what I wanted to explore, is that although I believe, and I'll get into why.
I think he wants you to give him an answer,
Yes.
not explore it,
And-
an answer.
Well, and that's part of my answer, is that although I believe that there's a separate issue that just deals with newly discovered evidence, I also believe there's an issue relating to when a defendant, in this case Ms. Cole's due process was violated. To go to your point, what is the avenue? I believe when there is a clear due process violation, it's our position that this court can then explore it because of her right to due process.
But the thing is that there is, what vehicle? I mean,
Correct.
Once it's final, just to go back and explore whether there's a process, what vehicle are we talking about?
I think I can answer that more directly as this. That's the issue that we're here before, because there is no lane carved out for scenarios like this. When evidence is withheld from a defendant, and it's successfully withheld from the defendant for this long period of time, and then the defendant finds it and then looks and can't find a box to check it in. So in other words, Your Honor, I agree that there is no typical, when I look through the law, a typical filing to put this under that says, hey, this qualifies as a B, C, or D, but that's the point.
This is a court of law.
Correct.
Not a court of equity.
Correct.
So, and I'm looking at, okay, how do we have jurisdiction to deal with this supposed new lane of traffic that you're talking about?
All right.
And I don't know what it is.
All right.
I'm not aware of a new vehicle.
And so to answer that, and I believe that's what the case law that I focus on near the end of the brief, is that when you have a scenario where
What case law?
as relates to a judge being neutral and no
just
appearance
give me
of
the
bias.
case. Just give me the case.
The case pages, let me see. I'm on page 8 of my brief that deals with Davis v. Liberty Mutual Insurance. That whole page just deals a series of citations that talks about.
These are civil cases?
This
These
deals
are all
with,
civil cases.
these are cases that deal with the neutrality and the requirement of neutrality. Specifically, there's a State v. Reed at 213 Southwest 3rd, 792. It's all the same principle. There's a, looks like we're quoting Kennard on, there's multiple different cases. Some of them deal with State v. Lynn is another one, 924 Southwest 2nd.
Okay, so you're
92.
saying that we have jurisdiction based on State v. Reed?
I'm saying based on the entire page 8.
The
page
entire
8.
page 8?
Page 8 of my brief list, all the different cases that deals with, and again, remember, there's two separate and distinct arguments. One is whether that this qualifies as a writ of error quorum nobis, which I'll get to. But the argument we're talking about now is that, to answer Justice Campbell.
I just feel like you haven't answered his first question.
Well, see, and I guess, well, let me try to.
And it's up to you how you want to use your time.
Well, let me rephrase it then. When there's a scenario such as this, where a defendant finds out evidence for the first time after a year that was not provided to her by the state which she was entitled to have, the question becomes, what box does it fit in? I believe was his question. My answer to that is, we believe that the court can decide that for due process purposes alone would be the box it fits in, due to the fact that to decide otherwise would be to
okay.
suggest.
So you're saying it's the way it's framed from our perspective.
Mm-hmm.
It's equitable tolling, okay?
That's part of what we argue.
Okay, what else? Because that's the only way.
Well, and again, and that's what I'm exploring, and I'm hoping that Your Honor
Well, I
would
wish you
agree.
quit saying exploring.
Well,
We have
because
to have a legal basis.
Well, outside of equitable tolling, I believe that the law should be interpreted to say that when there is evidence that the state withholds, and not just limited to equitable tolling, because the problem we run into, let me say this,
But that's
when you
what the
deal
law
with
requires.
equitable
We do this
tolling,
with-
is that this turns into almost a hamster wheel for the defendant, because equitable tolling, you say, well, then equitable tolling to what? When we argue post-conviction, and I've argued before this court before, I've been told, well, when you've already had one post-conviction, you don't get another one. So when we find out this evidence after post-conviction, it doesn't become, I've been told, it's not post-conviction. And so, and if it's not a motion to reopen, as I was just again told, because it falls under specific categories that a motion to reopen.
We're not just making it up.
No,
We're not, this is not us just telling you.
I understand
It's the
that.
law. It's what the
I understand that.
legislature
And so what
put
we're
down
here.
in the code
I
for
understand.
us to follow. So
And
we're not making it up.
And again, to the extent it was under the impression that I was saying that you were pulling this out of thin air, I'm not suggesting that. But what I'm saying is, when we're in the scenario, the defendant, when this occurs, and you're looking through the different boxes of what you can file, and you don't see something there, what we're asking this court is that when a scenario happens like that, where the evidence is provided to the defendant, through no fault of the defendant, after a year and after they filed a post-conviction, our position is it has to be considered, it has to be something, because to conclude otherwise would simply tell the state, if you have information and you don't want the defendant to have it, make sure they don't find out about it at least until a year passes. And I know as a court of law, that is, I don't read any of the case law to be interpreted to say that's the goal of what we want to promote. And so, but I agree, there is, for that first argument, there is no box it neatly fits into, because when we argue motion to reopen, I'm told, well, it's not DNA evidence, it's not a change to the law, and then the motion to reopen gets shut down.
Did you file I don't know what you're calling it.
The initial,
Well, it looked
no.
like it was entitled writ of error quorum
Correct, that
nobis.
was a pro se,
Right, so
that was a pro se
a
file.
pro se litigant filed a writ of error quorum nobis.
Correct.
Right, and it was untimely.
So, and that's,
It was untimely, correct?
without tolling, it would be considered
That
untimely,
means
because it's
it's
been more than a
Exactly.
year.
It's
Okay.
6 years late.
Yes, and
So that means that the filing must have included a reason to toll.
And I submit that it does, because the filing says, I never had this information.
No, but let me stop you for a second, because I don't want to get off exploring. I want to focus on what the law requires.
Correct.
The petition does not establish anywhere when the defendant got this information. Doesn't have anything in there. The co-defendant raised it 4 years ago, okay? And you know about the co-defendant because you represent the co-defendant. He raised this over 4 years ago, okay? We don't know when we don't know how, she may have found out about this 4 years ago and then just now raised it, which, it's not in there. We don't have any information at all to justify the tolling if she doesn't put it in there and give us some information.
And on that note, then I would ask that the matter be remanded so that can be fleshed out, because
But that's her responsibility.
Well, when you look at the order, and I don't want to misstate what the order says, the order basically, from my understanding, the trial court order basically did rule on the merits and basically said this is not the type of
That's not a
evidence
thing,
that
Mr.
would
Tootin.
qualify.
That's not a thing. That's not a thing.
The trial court order?
Remand for the petitioner to fix
Well,
the
no,
filing.
No, not to fix, but when you look at what the trial court's ruling was, and again, I'll let the record speak for it, but I don't recall the trial court ruling saying that she had this and she knew it and she didn't present it. I understood the trial court's ruling to be saying that this is not the type of evidence that qualifies for a writ of error, which we respectfully disagree with, but we believe that that's the issue.
Can I ask you a question?
Yes.
Have you been successful in any of these? I've had you multiple times on error quorum notices and I guess post-conviction petitions. Have you been successful in your interpretation and advocacy of the law in any of them?
Yes. So as specifically on a post-conviction.
On a writ of error quorum notice?
No, I'm specifically on a post-conviction.
Okay. Talk to me about a writ of error quorum nobis, because I struggle with your lack of understanding of this area of the law. In as much as I see you, I struggle with your lack of understanding. So talk to me about, you repeatedly come up here and you repeatedly tell us what you think the law should be.
Okay.
But I don't think you understand what the law is. We can't apply the law in a way you want it to be.
Well, and that's why I will respectfully give a little bit of pushback and disagree. I don't believe this is an issue of me not knowing what a writ of error quorum nobis is or what the standards is. I believe what this is, specifically as it relates to the first argument, is me asking the court to consider how to interpret the law in a scenario where evidence is received to a defendant after a year, after they've had a post-conviction, but it was through no fault of their own. And for that argument, so that I'm being clear, I don't classify that argument as an argument for writ of error quorum nobis. So maybe that is part of the confusion. What I specifically say in my issues is that there's two different issues.
The fact of the matter is, if you don't consider that to be quorum nobis, what else can it be? I mean, if it's not quorum nobis, then there's nothing we have jurisdiction over.
I believe we might be missing each other, and I apologize if I'm not being clear, because what I'm saying in the issues is I'm saying there's two separate issues. One of the issues I am saying is a writ of error quorum nobis. Okay. That is what the jurisdiction, I understand that we could all agree if this is considered new evidence, if it's timely, it would qualify. That is one of the arguments. A secondary argument, so that we're being clear, is separate from the argument of writ of error quorum nobis. It is me on behalf of the defendant asking this court to consider and then interpret the law to mean that when you have evidence that a defendant did not receive prior, and through no fault of their own, they now have it, and it's been years after they could have done anything else, they've already done their appeal, they've already done their post-conviction, that can be interpreted as a due process violation. And depending on how the violation occurred, I would ask the court to then interpret what the next step. Meaning,
what law? What law?
Well,
what case have you seen us do that?
The law saying that if you now find evidence,
making what sounds like a standalone due process claim.
So what
what you're saying. That's what it sounds like you're saying.
What I'm saying is I want the court to consider it separately as a due process claim. as well as a writ of error, two separate arguments, because what I'm saying is when you have a scenario like the scenario one, that's not a writ of error, if the court is brought to their attention and the court concludes that this judge or a trial court judge was either not neutral or as neutral as they should have been or had a bias or an appearance of bias, there should be a remedy for that. So in the alternative, let's say this. To say that there's no remedy, then we would just ask for a ruling that says, and even if we conclude that this judge was biased and we conclude that what they did was improper and we conclude that this was not fair to the defendant, because they didn't find out about it later, there's nothing that could ever be done, and let it go and don't bring it up, and then I will let that argument go. I'll probably always still raise it because I believe the law needs to be changed. As we've seen recently with our Supreme Court, laws can change no matter how long the precedent has stood before.
Well, let me ask you
I
this,
plan
though.
on
This
keep arguing
argument you're
this, though.
making about the court, about this whole thing, wasn't that raised by Mr. White in his post-conviction? The court denied it?
It may have been. I did not do his post-conviction.
Well, but I
so-
mean, she
but-
should have been, this is the same argument that was made in that case. I would hope that you would have looked into, since it was raised, the court denied it, and the Court of Criminal Appeals affirmed the denial, that it wasn't, this did not raise to the level of recusal.
And
So,
And if that's the position, then that's the position. But what I'm saying is when you look at the judge's order, I didn't interpret the judge's order in the trial court on this case to be saying that. What I interpreted the order to say is that this is not the type of ground in which new evidence would be considered for a writ of error quorum nobis.
Okay, and then the Supreme Court a week or so ago said that in order to qualify to get a stale quorum nobis heard, there has to be allegation of actual innocence. There has to be clear and convincing evidence of actual innocence. That's not in here either. You don't even approach that. You don't even talk about that. So what are we supposed to do?
Well, and again, it goes back to the comfort level of if you have a matter. So, for example, part of the reason this case has been brought forward and she had to go to trial is because there was a suppression hearing. Well, the question becomes, if the judge was not neutral, fair, and impartial, should they have even been hearing, and I understand I'm in my rebuttal time, should they have even been hearing the suppression issue? And if the evidence is suppressed and you enter a verdict of not guilty, that would be considered innocent. Because here's the other issue the defendant runs into. She's argued actual innocence and has said she's been innocent. And so what the issue we run into when we come to the Court of Appeals then is, well, that's already been argued and that's already been heard. My point is, it hasn't been heard now in light of this new evidence. She's been arguing actual innocence since she started from trial saying not guilty. We've been making these arguments.
That's not what we're talking about for quorum nobis.
But she submitted, the crux we run into is to cite those arguments. I then get turned around and I'm told, well, Mr. Tootin, that was already heard. That was already argued. That was already said. And the point, what I'm making is when those things were said, this new evidence was not available. And so it's like one hand is tied behind her back. She doesn't get to rely on the new evidence and then in light on her previous arguments. The previous arguments are considered too late because they were already ruled on. And then this new evidence is treated as separate and isolated as opposed to in its totality. And so I believe we have argued actual innocence multiple times, and it hasn't been considered because the new evidence wasn't there to accompany it. And so we believe that it is a reasonable thing to do is to have this matter reversed if the court concludes that this is evidence that she did not previously had. And I didn't read in the order anything that suggests a trial court saying she had this the whole time and she just waited to submit it.
All right, thank
Thank
you,
you.
Counselor. General Coleman. Good morning.
Good morning, Your Honors,
Still
and may it
morning,
please
I
the
think.
court. Ronald Coleman on behalf of the state. This court should affirm the denial of quorum nobis relief. And I want to take a few things before really getting into the crux of quorum nobis. So first, the defendant today has sort of said the label's not relevant and this could be seen as a post-conviction reopening, things of due process violations and stuff like that. The petition filed in the trial court was called itself a petition for writ of error quorum nobis. In that petition, it alleged, quote, newly discovered evidence and claimed that this was evidence that could prove her actual innocence. So this was only under the ground of quorum nobis. To the extent we have post-conviction reopening or any other type of issue before this court, that was not presented in the trial court. Briefly as to, I believe the words pulling this out of thin air was said earlier, and essentially I think that's sort of what the defendant would like this court to do to get to the due process claims. She cites page 8 of her brief that only talks about the substantive constitutional rights to have an impartial judge. That does not in any way create a new procedural vehicle to raise these claims collaterally after a judgment has become final. So really the only thing we are here today on is the petition for writ of quorum nobis and the trial court's denial of that. And then again, before I get to the crux, the petition or the defendant repeatedly said that the trial court's order did not deny relief based on this prong or that prong and focused on the merits. But it is her burden to meet each and every single step to establish quorum nobis relief, and this court can review it in all of those ways. So here, this court can affirm the denial for a variety of reasons. First, it can find that the petition was untimely. It was filed 6 years after her judgments became final, so it was untimely. Second, it can find that tolling was not appropriate. The petitioner did not allege tolling. She certainly didn't establish why tolling was appropriate. To your point, Judge Campbell, she never even alleged in her petition when she discovered this information and when she got this transcript. And so she has not met her burden of establishing that it was new to her or that tolling was appropriate for any reason. Third, it does not qualify, and the trial court actually found this does not qualify as newly discovered evidence. For something to be newly discovered evidence, one of the important things is that it has to be admissible at trial. The complaint of information here is a transcript of a co-defendant's transfer hearing.
Well, it really wasn't even a transfer hearing. From what I understand, the state was just asking to have the co-defendant transferred from Riverbend, I think, to come in for his arraignment. So
Correct.
It was an uncontested matter, and the defendant that was involved, Mr. White, was not even hadn't even been arraigned yet.
Correct. That's my understanding as well. Certainly what it was we have this co-defendant. He is in prison. We need to get him here so that we can have him before the court. And that's all it was. Mm-hmm. That is not in any way admissible at this defendant's trial. So it does not qualify as newly discovered evidence. And then even if this court wanted to get past all of those, call them procedural hurdles, there's no way that this might have changed the outcome of trial. Again, all it was a conversation. They had the transfer order got rung up, and the prosecutor said this might be an interesting case.
But also, I think, especially after Clardy last week, how does this establish actual innocence?
That's another prong that this court could deny. It does not go to actual innocence in any way. And so whether this court wants to address that on the untimeliness and tolling, which is part of what Clardy said, is to get tolling, this has to be evidence of actual innocence, or whether it wants to address it on the merits. This court sort of has a litany of options for how it can affirm. But if this court doesn't have any questions, we certainly ask that it does affirm the denial of quorum nobis relief. Thank you, Your Honor.
Thank you, General Coleman. 3 minutes.
I just heard the litany of options to affirm. I'm going to give you the option to reverse and remand. And I believe one thing that at least we can all agree, and as opposing counsel just made the references to page 8 of the brief, that there is a constitutional right to a fair and impartial judge. I believe everybody's agreement in that. We're all hopefully saying the same thing. To frame this issue a different way so that it doesn't come across as me saying we just want to pull a rabbit out of our hats and pull anything whole cloth. I think maybe it's better said, and again with opposing counsel's statement, that actually leads into my point. If we all agree that everyone is entitled to a fair and impartial judge, and that this is a constitutional right, and that the courts uphold the Constitution in the state of Tennessee, then if that right is violated, and we know that it was violated, what is the remedy? What I'm suggesting in one of the arguments we're making is that there has to be a remedy, and the law that allows it is what was just said, that there is a constitutional right that the court is made aware of that was violated. That's what I'm saying. That's what I'm arguing. I understand that a writ of error, a quorum nobis, gives you one box. I understand that a post-conviction gives you another box. I understand that a motion to reopen post-conviction gives you another box. I'm understanding of the law on all of those things. What I'm saying is, what happens if there's this other box where we know that the constitutional rights are required to be upheld, and we have reason to believe, if these arguments, if it's believed, if the court concludes that this was not proper, because if the court concludes, I don't have a problem with this hearing, and I don't believe the public has a problem with this hearing, then that's all we presented. We have nothing. But if there is a concern about that hearing, and we understand that the law has to be interpreted, the Constitution has to be protected, and there's a constitutional right to a fair and impartial judge, and you've concluded that this was not what the defendant received, then again, the question is, then what do we do about it? And if the answer is nothing, because we only are aware of these these boxes here and there is no other box, then so be it. Say it out loud, put it in the brief, and I'll still argue it, just so you know, going forward, because I think it's an issue that needs to keep being raised, but I'll respect it.
Anything that he said?
Yes, I understood him to say
You're
that
not
there's a
addressing
constitutional
any
right.
of the arguments that he laid out. You've not
Correct.
addressed any of them.
Correct. And I'm focusing on the issue that I find most important to the first of the two issues, which is specifically there's an issue of writ of error quorum nobis, and I'm spending this rebuttal talking specifically to an issue of whether or not we have a judge who was not impartial, and is there a remedy for that? Because if the answer is no, we as a society, as the defendants, as the attorneys, we need to know that there's nothing they can do, so we can tell our clients, don't worry about it. They hid the evidence long enough to now you'll never receive justice on it. Because if that's what we need to advise our clients, we will, but we need it to be clear, and that's what I'm arguing. Thank you.
Thank you, Counselor. All right, call the next case, please.
State of Tennessee versus Christopher R. Smith.